Hi, my name is Audrey Oo.
I'm Seow Xue Xi.
My name is Lee.
I'm Lim Xin Wei.
My name is Sabrina Ying.
I'm Ke Xin, and we'll be talking about the landmark case of Donoghue and Stevenson. Please enjoy our video.
Donoghue went to Well Meadow Cafe with a friend who had ordered ice cream and ginger beer for Donoghue. Donoghue's friend had paid for her meal as a treat. The ginger beer bottle was made of dark opaque glass, and they had no reason to suspect that the bottle contained anything else other than ginger beer. Donoghue had consumed most of the drink before pouring out the remaining drink, where a snail in the state of decomposition was poured out, and then the nauseating sight caused Donoghue to sustain shock and suffered gastroenteritis. Donoghue brought an action against Stevenson, the manufacturer, where she claimed £500 as damages for injuries sustained by her consuming ginger beer. The manufacturers raised the defense of privity and claimed that since the plaintiff could not sue them in contract, she could not sue them in tort either. The case was brought up to the House of Lords.
So, the House of Lords held that there can be a remedy in tort and the claim was allowed. A manufacturer had a duty of care in negligence to the ultimate consumer of his products. The reasoning behind the decision was given by Lord Atkin. He said that you must take reasonable care to avoid acts or omissions which you can reasonably foresee would likely to injure your neighbor. Besides that, Lord Macmillan also elaborated on the liability of manufacturers. Products made for human consumption by the manufacturer imposes upon him a duty of care to avoid injuring those who intend to consume his products. Hence, the claim was allowed. In conclusion, duty of care was established in Donoghue and Stevenson, which is also known as the snail in the bottle case, which is now the modern action for negligence. This landmark case provided a precedent for future civil tort cases of negligence, and businesses are also now obliged to owe a duty of care towards users of their products. This case birthed a new area of law to the benefit and detriment of some. For example, personal injury, which is steeped in both statutory duty and the neighbor principle.
Before the neighbours principle is established in the case of Donoghue and Stevenson, there is no test to establish a duty of care in the absence of the privity of contract until 1932. This was illustrated in the case of Winterbottom and Bright in 1842, where there is no ability of claim when the claimant is not a party to the contract. In this case, the defendant contracted with a postmaster general to supply a mail coach with the purpose of carrying the mail along a particular route. In other words, to provide a coach in good order. However, the driver of the coach, which is the claimant, was injured when the axle broke and he was thrown from the coach. In the end, the claim failed and the court ruled that the driver had no action against either the postmaster nor the coach rider for the breach of the contract. It was also established that they could not consider negligence because the contract was between the postmaster general and the coach owner and not with the claimant. One of the very first attempts to formalize the duty of care was in the case of Heaven and Pander in 1883. In this case, the defendant, the owner of a dry dock, entered into a contract with the ship owner to supply a stage which was supported by ropes which should be flung over the side of the ship while it was on the dock. There's the painters who are employed by independent contractor who would be using the stage to repaint the ship. Whilst painting, the stage collapsed and injured a painter. The ropes had been scotched before they were supplied by the defendant, who had failed to give reasonable, careful attention to their condition. The injured painter sought to sue the defendant, however he had no contract with the owner, so he sued in tort. In the dicta of Brad M.R., it was established that under circumstances, one may owe a duty to another even if there is no contract. However, he was part of the minority, with the majority giving a more narrow interpretation, where liability can only be found in the area of tort, where there is an action between the owners of the premise and licensees. The painter was not licensee, so he could not be successful in tort. Another case would be George Skivington, which is treated as an authority for the proposition that a vendor of goods might owe a duty of care to a person other than the immediate purchaser of them. It was criticized for over half a century until finally vindicated in Donoghue and Stevenson. A more recent 20th century case before Donoghue would be Dominion Natural Gas and Collins, where the duty of care was also partly established before Donoghue. Thank you.
The decisions made from the case of Donoghue against Stevenson have made significant outcomes in negligence under the law of tort. The legal principle that can be made out from this case is that there is a duty in tort to take reasonable care to avoid acts or omissions which can be reasonably foreseen that are likely to injure your neighbor. According to the article Love Thy Neighbor by James Wilson, this case has developed recognition and enforcement of private bargains that are voluntarily concluded by ordinary citizens by the court. The case has established that manufacturers have a duty of care to the end consumers or users of the product. According to Lord Atkin's ratio decidendi, a manufacturer of products which he sells to reach the ultimate consumer in the form in which they left him owes a duty to the consumer to take reasonable care. This precedent has evolved and now forms the basis of laws that protect consumers from contaminated or faulty goods. Not just that, it has developed the neighbor principle by Lord Atkin. The neighbor principle for establishing a duty of care can be broken down into reasonable foresight and the relationship of proximity. A relationship of proximity has extended the tort of negligence beyond the tortfeasor and the immediate party. In the context of the neighbor principle, neighbor is not necessarily someone who lives next to you nor in your neighborhood. Instead, the term neighbor here, according to Lord Atkin, refers to persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions which are called in question. Thus, the tortfeasor is required for a reasonable foresight as well, where in this case, the manufacturer is to have a reasonable foresight on the events that may happen. As can be seen, the neighbor principle has become the sole criterion for determining whether duty has arose.
Since the establishment of the neighbours principle, there have been incremental development in the principle of the duty of care. Duty of care has expanded to several categories of cases such as manufacturer to consumer, teachers to pupils, occupiers of land to visitors, and skilled professionals to their clients. The case of Grant against Australian Eating Mills is an example in which the manufacturer's duty was illustrated. The plaintiff contracted dermatitis after wearing woolen underpants which had been manufactured by the defendants. The Privy Council held that the defendants were liable to the plaintiff. As manufacturers of products, they should have knowledge that the absence of reasonable care in the preparation or putting out of products will result in an injury to the consumer's life or property. Thus, they owe a duty to the consumer to take that reasonable care. The case of Carmarthenshire County Council against Lewis demonstrates the duty of care from a teacher to a pupil. In this case, the driver of a car was killed when he tried to avoid a child who ran onto the road. The school authorities were held liable for letting the child out of the school compound, as it was foreseeable that a child could cause an accident. Moving on, the concept of duty of care was expanded in the 1970s. This can be illustrated in the case of Home Office against Dorset Yacht Co. Ltd. In this case, a group of young offenders escaped from a Bosra home and caused damage to the plaintiff's yacht. It was held that the Home Office, whose employees should have been controlling the youths, owe a duty of care to the plaintiff. The extension of the neighbour principle in Home Office against Dorset Yacht was novel for two reasons. Firstly, the wrong against the plaintiff had not been committed directly by the defendant or his employees, but rather a third party. Any liability of the defendant would then be based upon the omission, that is, his failure to control the actions of the boys. Secondly, the defendant were public body subjected to statutory and resource constraints. In the case of Ants against London Borough of Merton, the two-stage test was established, which taken up Lord Street's suggestion in the case of Home Office. Lord Wilberforce created a two-stage test in determining liability. The first stage was based on the neighbours principle on foreseeability and proximity, and the issue was whether the harm to the claimant was foreseeable to impose a duty of care. If the answer to the first stage is affirmative, in the second stage, the courts will have to consider whether any policy grounds negate, reduce or limit the scope of duty to be imposed on the defendant.
However, there are problems with the two-part test that was introduced in the case of Ants against Merton. After an initial period that saw massive expansion of liability in negligence in the courts reluctant to apply the expansionist interpretation of Lord Wilberforce's speech, whilst recognizing the strong policy element which inevitably influences determinations of proximity. Lord Wilberforce's interpretation was finally laid rest by Lord Keith in Yuan Kun Yew against Attorney General of Hong Kong. Lord Keith in Yuan Kun Yew said that Ant's test as laid down by Lord Wilberforce had been given more importance than it ought to, and that in future cases this test need not be applicable and relevant in establishing the existence of a duty of care. Criticisms continued, and the departure from Ant's case finally came to an end when the case of Caparo Industries against Dickman was heard. Caparo is the landmark case which has created the tripartite test in establishing a duty of care. This test departs from Donoghue against Stevenson and the Wilberforce test laid down in Ants against Merton, London Borough Council, which starts from the assumption that there is a duty of care and that harm was foreseeable unless there is good reason to judge otherwise. Whereas Caparo starts from the assumption that no duty is owed unless the criteria of the three-stage test is satisfied. These criteria are foreseeability, proximity, and whether it is fair, just, and reasonable to impose such a duty. Yet, this approach has been critiqued by overcomplicating labour principle in Donoghue. Moreover, there is an abundance of case laws which moves away from the Caparo test altogether. The three-part test in Caparo was applied by the House of Lords in Murphy against Brentwood District Council, overruling Ant's decision. The defendant local authority had negligently approved plans for the footings of a house. The claimant purchased the property, but sometime afterwards it began to subside as a result of defects in the footings. The claimant was unable to afford the property as a loss. He also claimed damages for the health and safety risk which the defects had caused to himself and his family during the time they lived at the property. The issue was whether the claimant was owed a duty of care with respect to the damages which he had suffered as a result of the defective footing which had been approved by the defendant. Declining to follow its previous ruling in Ants against Merton London Borough Council, the House of Lords held that as the damage suffered by the claimant was neither material nor physical but purely economic, the defendant was not liable in negligence. It was decided that to allow the claimant to recover damages for the money which he had lost on the sale of the property or for the cost of repairing it would result in unacceptably wide liability which would effectively amount to judicial legislation introducing product liability and transmissible warranties for defective buildings.
In conclusion, a duty of care is a legal obligation which is imposed on an individual requiring adherence to a standard of reasonable care while performing any acts that could possibly harm others. It is the first element that must be established to proceed with an action in negligence. The claimant must be able to show a duty of care imposed by law which the defendant has breached. In turn, breaching a duty may be subject an individual to liability. The outcome of Donoghue has reverberated through the law as a whole. It is essentially birthed a new area of law to the benefits and detriments of some. For example, the personal injury which is steeped in both statutory duty and the neighbour principles. Indeed, it has grown to the point where there are concerns of compensations culture best expressed by Lord Hophouse, where he linked it into the restrictions of the liberty individuals. The pursuit of unrestrained culture of blame and compensate has many evil consequences, and one is certainly the interference with the liberty of the citizens. An individual may own a duty of care to another, to ensure that they do not suffer any unreasonable harm or loss. If such a duty is found to be breached, the legal liability is imposed upon the tortfeasors to compensate the victims of any losses they incur. The idea of an individual owning the stranger a duty of care, where beforehand such duty were only found from contractual agreements, developed at common law. Throughout the 20th century, the doctrine was significantly developed in the case of Donoghue and Stevenson.
Thank you for watching.